how does the car accident lawsuit process actually work? What's going on, everyone? My name is Peter Geraci, the Slam Dunk Attorney. My goal is to make sure that everyone with a car accident case makes their case a slam dunk. Now today, and in this video, we're going to be breaking down what the car accident lawsuit process actually looks like. Now, this is a little different from our previous video where we would discuss the actual claims process. This is after you've gone through the claim. This is after you've tried negotiating with the insurance company. And this is after you've decided, hey, I'm not going to take what they're offering at the beginning of this case. Okay, so we're going to be discussing the actual litigation process that follows after you've decided, I'm going to file a complaint in the appropriate court. Now, and as always, I have to do this, just a quick disclaimer. Most of this is only going to apply to cases that have occurred in Georgia, where you're filing the case in Georgia. A lot of the concepts may still be applicable. I just can't guarantee that you'll have the same results in a different state. Now, a lot of people might wonder or might be thinking, why would I even get to this stage, right? Why wouldn't I just take whatever the insurance company is offering me? Well, a lot of times the insurance companies are going to be lowballing you, right? They think, hey, this person isn't actually going to file a lawsuit or force us to pay for anything, so we might as well just offer them something low and in hopes that they go away. And you'd be surprised, most people actually tend to take the offer, right? Most people aren't willing to go through the process of litigation. It's a very lengthy process. You know, most cases will take anywhere from 1 to 3 years, depending on the complexity, to complete. And so it can be a huge deterrent for a lot of people when it comes to filing an actual lawsuit. But I'll say this, in most cases where the insurance company is lowballing you and you have a solid case already, filing a lawsuit is only going to serve to make your case better. The reason is the insurance company is actually going to take you seriously. They see an actual potential threat behind the case. And the real threat behind the case is either a judge or jury telling them that they need to pay you a certain amount. Not the amount that they think is the value of the case, but the value that the judge or jury thinks the value of the case is. So with that in mind, let's go ahead and jump right in. The first step in your car accident lawsuit or the car accident litigation is preparing the complaint. The complaint is essentially a legal document that's a short and plain statement of the facts and basically the reason you feel like you are entitled to relief. Now, as I mentioned, this will just be related to Georgia, and Georgia's standard for what you need to put in the complaint is just a short and plain statement of the facts and why you believe you are entitled to relief. Generally, it's best to tie your facts to a particular law or cause of action that you have against the defendant. Now, in most cases, your defendant in the case is going to be the other person that hit you or caused the crash, and the law or the cause of action that you're going to be bringing is negligence. Now, negligence is just generally defined as the failure to use reasonable care resulting in damage or injury to one another. Typically, negligence has 4 elements. You have duty, breach, causation, and damages. Duty and breach, in a situation where liability is clear, where the other person is clearly at fault, are pretty simple to establish. Most often, the fight is going to be about causation, whether the accident or wreck actually caused the injuries you're claiming, and then the extent of the damages, what your case is worth, as it pertains to this particular case. So in your complaint, you need to detail facts that go to these elements, right? To duty, to breach, to causation, and to damages. You need to show that you can make your case on its face, just to be sure that you survive any sort of motion from the other side that suggests, hey, this person doesn't have enough to even make it to a jury. You need to plead sufficient facts to get by a motion to dismiss. Now, once you've got the complaint filed, the next step is getting your complaint served. Now, you cannot personally serve the complaint upon the person that caused the wreck. You need to hire a process server or use the local sheriff's department to serve the defendant or the person that caused the wreck. So you just send the complaint over that you got back from the court after you filed it over to the process server or the sheriff that's going to be handling a service for you. Once service is complete, the defendant has a certain number of days to respond and file their answer in court. If they don't file their answer within a certain amount of time, they'll be in what's called default, meaning you'll win by default. Now, generally, and in Georgia, specifically winning by default doesn't necessarily mean you're entitled to all this money. What it means is that you won't have to prove your duty, your breach, your causation. All you have to prove is damages. Okay, so you'll be entitled for a hearing on damages. And so you'll go in front of the judge or the jury and you'll present your case on damages to why you think your case is worth a certain amount. Now, let's say the defendant does answer. Once the defendant answers, you start the process of discovery. And this is the actual next phase of the case. This is one of the longest phases of the case. And discovery really is where you go through and each side gets to do their investigation, do their due diligence into each other. This is where you're exchanging documents, sending questions or interrogatories to each other. You're requesting documents from each other. You're requesting admissions from each other. And you're also engaging in depositions. A deposition basically is a sworn interrogation under oath. Okay, the other side or you will get to interrogate the other party or ask the other party questions for an extended period of time about the case and about them. The whole purpose of it is so that you can learn as much as possible about this case, this person, and everything that you might need to know in the event that this case actually makes it to trial. Now, depositions aren't only restricted to parties. You can depose witnesses, you can depose police officers, doctors, biomechanical experts, accident reconstructionists, all kinds of people will be deposed during discovery. And so that's why the process is a little bit longer. Generally, and in most cases, the discovery period's around 6 months, but it can be a little bit longer depending on the court that you're in, the judge that you have, and the complexity of your case. Now, most people might be wondering, like, hey, once I file a lawsuit, is the insurance company ever going to want to settle with me again? Like, am I going to have to go to trial? Is that it? And the answer to that is no, actually. There are plenty of opportunities within the litigation process for you to resolve your case, even right when you file, right? Because the insurance company's like, whoa, we want to get ahead of this and try and resolve it before we spend a lot more money and hiring an attorney to defend our case. They may try and offer you something then. Oftentimes they'll make an offer after your deposition, right? After they see the kind of person that you are and how you present, they may decide, hey, I'm going to offer this person a little bit more money because I'm scared about how they'll present in front of the jury. And there's also an opportunity even after discovery ends, and usually it'll take place during mediation. Now, mediation is a process where both parties will go in front of a third-party neutral, somebody that has nothing to gain from the case, has no interest in the case other than to try and help y'all find a resolution. Now, mediation can be pretty costly depending on the type of mediator that you use, but it can be well worth it in a situation where you feel like maybe this case isn't strong enough to take to trial and I'd like to try and get it resolved here instead. Or if you just feel like maybe the mediator can help pressure them and help the other side see what they're missing. It can also be a good opportunity for you to get an insight into what the strategy is. All in all, mediation can be a really powerful tool for you to use to either settle your case or learn a lot about the other side's case to prepare you for trial. Now, let's assume your case does not settle at mediation and you are moving forward towards trial. Preparing for trial can be a really daunting task. It can involve a lot of time reviewing records, documents, preparing witnesses, reviewing deposition transcripts, and strategy implementation that can be really daunting for a lot of people. But at the same time, if it is something you're passionate about, it can be a really enjoyable part of the process. This is where you get to gather all your evidence together and make it fit the puzzle and the picture that you're really trying to present to the jury so that they understand where you're coming from and why you deserve to win your case. Now, in most situations, you're probably not going to get your trial date immediately. It's going to take some time for the court to fit you in on their calendar. But once you do have that trial date set, it's best to get prepared as soon as possible. You're going to have to get your witnesses ready, all your evidence ready, all your documents ready. Everything you're going to need needs to be ready for that date. Now, once the trial date comes, you're going to go in front of the jury and you'll start to present your case. Now, once that trial date comes, you'll be able to go in front of the judge and the jury and start to present your case. Now, there are a lot of evidence rules and other court rules that apply to whatever is being done and said in court, so it's best that you brief yourself on what those rules are before you go up there and start presenting your case. And then once both sides have finished presenting their case, the jury will go back to the deliberation room where they will start to deliberate and discuss the case and ultimately decide who they think should win the case. Once the jury indicates that they've reached a verdict, they will come back out, and then the verdict will be read to everyone in the courtroom. And then really at this stage, what the verdict says is what the verdict is, and that's what the resolution is going to be for the case. There are a lot of opportunities for what we call post-trial motions, where either side could file a motion with the court to possibly nullify the verdict that came back, or change it, or ask for a new trial or a mistrial, or a number of other things to potentially change the course of the case. But in most situations, that jury verdict is going to hold unless for some reason it doesn't comply with the law, or it's inconsistent with the law or the facts as they were presented. Once you have your verdict, that's pretty much it. The insurance company on the other side is going to be responsible for paying that verdict, and if they don't, then you can get the judge to enforce that. Now, just as an overall point, most cases are not going to make it to trial. That's just a fact. Most cases will resolve well before that. But I just wanted to give y'all the full picture, the full perspective of what could actually go on in a given case. This time period from when a lawsuit is filed to when a trial actually happens, like I said, can be anywhere from 1 to 3 years depending on the complexity of the case. Most people don't have that kind of patience and the ability to really wait until that time when they get to have their day in court. And so you'll see most people just settling for something maybe a little bit less than what they think is the true value of their case. All right, guys, well, that about covers it. I hope this was helpful. I really just wanted to provide y'all with an overall look at what the lawsuit process looks like, just in general. If y'all would like a little bit more in-depth explanation of each of the phases in litigation, I'm more than happy to do that. Just let me know down below in the comments, and I'll be sure to get to it when I can. If y'all have any questions, comments, or anything else, please leave those down below. I'll be sure to answer as many of them as I possibly can. And if y'all have any ideas for any future videos, just let me know. I'm happy to take anything into consideration and give y'all the content that y'all really want. All right, and as always, thank you everyone for watching, and we'll see you in the next one.